was your former sense will be a quabba strong price of a King2 TV. And your first time I will check into TV. I must also be subscribing to King2 TV. Over like over comment your comment section. So over click on the notification button for more news updates. See, I said the case of Dr. Case Water Forcing on the third accused Richard Jacques. See, our case with any appeals court to you is answer. Your ruling case with now your ruling case with you know. And yes, say Dr. Case Water Forcing only the third accused only at fault. This is the kind of found it. When I'm so a Attorney General Godfrey the Odame say radio on Tiasia Sadia or better be as a way na as a kwakupemu with the Supreme Court of Ghana, the apex court in Ghana right now. Inti odi kopie mo hono na asema obekanyina and say two justices I Frebako Kwaku Akabuafo and a bright men's abusiafo. That case will omaye in trenchia asempa to say oma really case ni na case na kwa mo fast so omo really anasa omo final judgment ni na and say omo be share nsema eye atofos in any the third accused eka yenkwa ba bra mabre ewa appeals court emu cross examination ni emu for case dismisses ni ekeke ka ho ni na two justices and fine she. It is also what until one says or Marco say a year financial loss to the state 2.37 euros or my finding almost or mark which ever is a woman, but Otisadia or the Assembly Kakupimu with the apex court in Ghana, the Supreme Court. In terms of coming home, you could say the full interviewer a Godfrey Dami, a grantee, the Attorney General, you could see Sema Hodra or the Tutuja. The entire was the one tia say as is ya. Bibi abesha no kokoko na ya kra na dobe no anka enye enti no meso so be subscribe to King2 TV, like your comment your comment section uye so click on the notification button for more news updates yen chen ho no yen go ti masisia medas
2023 this are appealing on my vegetarian on the terminal and then that is why I am surprised by the outcome, but of course it's not the end of it. I mean, this is not the first setback in my effort to prosecute these financial crimes. Even open case in Pono, I had a setback, the same submission of no case ruling, which was made by the former judge, I think Justice Konyanuga, for Supreme Court first. So surprisingly, Supreme Court, ruling no, but that's Roniga. I have to go and review. I had success on review, and the ruling was reversed. The Samba High Court said we should have open defense law. Then there was an application made, and the trial judge then said we have to start afresh. We have to start de novo because by that time Justice Roniga. Again, under strange ruling, it was one that really was also against all reasonableness. I took it in my stride and I appealed against it to the Court of Appeal. And I succeeded. It just as it's normal, just as me, I'm used to know. But I appealed against this one. And I'm very sure that it will be set aside. But really, the ruling there, in my respectful view, most unreasonable. And it goes against the essence of all the authorities on corporate financial laws. Indeed, there is no case as clear as this one. There is no case in which the ingredients of corporate financial laws have been established in as lucid a manner as this one.
But Council, how can the Court of Appeal decision now, Minya BNC 125 pages, but I was just taking a cursory look. So I'm share because I majority into a 2-1. So we'll share the first justice our cat 2 nehona justice akabuafo paragraphs 149 150 151 of the decision na okawa 149 or say the evidence further establishes that the ambulances were initially parked at the forecourt of the State House, but they were moved to the Air Force Base at Burma Camp by the National Ambulance Service at the direction of the Ministry of Health sometime in November 2015. Mr. Foster Ansong Brijan, PW1, who testified on 31st May 2022, said, quote, "Looking at the time we parked them there, the current state, the vehicles have actually deteriorated," unquote. 115 or say, "My lords, if the above is accurate, in my respectful opinion, it defies logic that Jakpa at Business, agent of the supplier Big C, would be charged with causing financial loss to the state based on the fact in the record of appeal when the plan put in place to rectify the defect of the ambulances to enable their use has not been implemented because the government failed to meet its obligations under the roadmap agreed to in 2016. In any event, that roadmap leading to the shipment of the part to Tema Port was agreed upon between the Ministry of Health and Big C, not with Jakpa at Business. So it is not clear why Jakpa at Business would be asked, quote, to go and pay and clear the items to rectify the anomalies on the ambulances, unquote. As a corollary but to the foregoing, it bears mentioning that if there are vehicles, even if deficient in certain requisite parts, parked in Ghana, an action plan in place between the MOH and the supplier Big C to rectify the deficiencies and additional parts or accessories in storage at Tema Port for the said rectification, then there is a need to reassess the quantum of the alleged loss, a factor that impacts the case against all the accused in this case, and calling into question the maturation of the charges preferred against the accused persons. It's essentially, the justice of the court of appeal.
Yes, I heard everything. But the point, the judge, with all respect, misses the point. The financial loss was caused not because the vehicles were parked at the forecourt of the State House and were moved to a different location and were left to the vagaries of the weather. The financial loss was caused in the first place when the wrong specification of vehicles were even supplied. Number two, the financial loss was caused because the vehicles that came were not ambulances, were not fit for purpose, and indeed could not be converted into ambulance. And I've told you that indeed there was a report from Ministry of Health and National Ambulance Services which show that the vehicles that were supplied were so fundamentally defective that nothing could be done. And indeed, this report from the license dealers in Mercedes-Benz showed that the vehicles that were actually supplied could not be converted into ambulances. In this, we just vehicles see one more 10 days to 100 years to 10 weeks exit material. In the first place, the vehicles should not have been supplied. Wrong specifications supplied, not fitted with the relevant equipment, indeed could not be converted into ambulances subsequently. And if indeed a question which now converted into ambulances, from the part you really read, this thing that you're talking about occurred in 2015.
Yes. The
movement. How come from 2015 now up to 2017, our NDC for legal officer, they couldn't convert it into ambulances? How come they couldn't fix the equipment? Because it couldn't be converted into ambulances. And that is not based on the oral testimony, it's based on documentary evidence from the license dealers in Mercedes-Benz, which we have stated in evidence at the trial.
Then based on what?
No, but the point about the fact that even the court for appeal was split in the judgment,
yes,
supports my view. Say the judgment itself is not sacrosanct. It's not one that cannot be impeached, because even when the court for appeal was divided, it was a majority decision 2-1.
Yes.
And everything in my training and upbringing would dictate that such a judgment ought to be questioned. We have to test the soundness of the decision at the Supreme Court. Not as a matter of test the soundness. For me, it defied, with all respect, every reason. Because yes, the vehicles were supplied. Number one, the vehicles were wrong, were not the ones specified under the contract. Number two, the vehicles were bereft of all the necessary ingredients, as somebody would say, for one better expression, the necessary features of an ambulance. They didn't have all the equipment apart from that, they were defective. Even the engine capacity, the engine size that was set out in the agreement, the body and all that, all the interior parts were different from what was supposed to be supplied. Now, after that, more than 2 years, they could not be converted into ambulances because there's a report, technical report from those who deal in such vehicles, that those vehicles, with all respect, Ghana are useless because you can't convert them into ambulances. So, what again is a big deal? And as I said, so that's why I made the point there. You cannot have a much clearer case regarding financial loss than this matter.
Than this one. But now, me Busa Council say, based on what then would the Ministry of Health then agree with the suppliers on a roadmap to rectify, for which reason are some parts were imported into this country? And you clearly heard the Court of Appeal judge Akabuafu make that point, say that roadmap was between the Ministry of Health and the suppliers. No, if they don't understand why Japan at business would be implicated in this matter. You read the
So first and foremost,
yes,
even if this roadmap is valid, anything to go by, it's not after the fact. It's not after the wrong vehicles have been put into the country. It's not after the wrong specification and all the various breaches under the agreement has been committed. It's not also after payment has been made contrary to the laws of Ghana. Payment in favor of a company which did not have parental approval, even though they were supposed to have parental approval. Now, secondly, as I stated earlier on, which I'll repeat, indeed, that so-called arrangement to fix the ambulances could not be carried out because the vehicles should not be converted into ambulances. And it is not, I go for Odame say it is as per the evidence that was stated at the trial. So the judges examined that particular evidence or they ignored it. If that evidence was ignored, then that's basis for us to have the decision set aside. And I do not think that there was an adequate assessment of the evidence of the prosecution from the judgment as I have considered it clearly. And if you look at the judgment, the dissenting opinion of Justice Pukwechabo, clearly it examined all the ingredients of the offense. It also examined the necessary material pieces of evidence that were tendered by the prosecution. And I think that is what is most important. So where, with all respect, one judge decides to look only at one version of the facts and which will support a certain conclusion, well, I think that it's up to us to question it on appeal. And I do this not because of any emotional attachment about the case and all. Let me say, I hold a very important office, Attorney General, Minister for Justice. I'm responsible